Appeal number 62, Wilson v. Dantas. Counsel?
Madam Chief Justice, and may it please the Court, I request 2 minutes for rebuttal, please.
You may, sir.
The Appellate Division erred as a matter of law in basing its forum nonconvenience decision on a lack of a right to jury in the Cayman Islands and Brazil. This is error for 3 reasons. First, Mr. Wilson agreed that Cayman was a convenient forum in the shareholders' agreement. Second, Mr. Wilson has no right to a jury in New York in any event because he asserts equitable claims.
Counsel, that was just one factor, though, correct?
That was just one factor, but the Court should not let that factor stand lest it create an invitation like it did in the Pahlavi case. Another reason the Court erred on forum nonconvenience.
If we agree with you that the Court erred as a matter of law in relying on that factor, then wouldn't we want to send the matter back to the Appellate Division to reconsider all the other factors in light of the fact that that one factor would not be appropriate?
That's certainly one option. However, I believe that in this case, much like the Mashrek Bank case, the factors are clear and this Court can render on the issue of forum nonconvenience.
Well, let's say we disagree, and whereas Judge Stein says in a position that we think the correct course is to send it back. What's the point of that? Don't you have that as a defense now against the amended complaint? Isn't that now under consideration?
Well, the issue of forum nonconvenience, Your Honor, is to allow the Court to decide up front that with the inconvenience of the parties, the other factors, including the burden on the Court, which is substantial here given the Cayman law issues involved, that the Court...
True, but Supreme Court never had enough... True, but Supreme Court had not rendered a decision originally on the forum nonconvenience. The Appellate Division addressed that matter, so now you'd have the Supreme Court addressing the matter as the initial court where it should go.
That is where it should have been done, but much like the clock at 100 Center Street that was repaired. This is an issue that should get done right. We're here now. It ought to get resolved. The issues are clear when you apply the Mashrek Bank factors. Indeed, my opposition doesn't even respond to the Mashrek Bank factors. So once you get to that...
If we disagree with you and think the Appellate Division should be affirmed, does that foreclose consideration of your defense that you've got now below on the forum nonconvenience?
It does not foreclose...
Because you're still seeking dismissal based on forum nonconvenience.
We can still seek dismissal on that basis. In fact, there's a pending motion by the other side on that issue now, and that issue can be resolved. However, that would require the parties in an already advanced case to go back to the Supreme Court, then perhaps to the Appellate Division, then perhaps up here, to have the issue finally resolved when it can be resolved on the factors that exist now.
No, but I'm just saying, if we affirm the Appellate Department, think they've properly exercised their discretion, does that foreclose, is that law of the case? Does that mean that you are not going to be able to argue forum nonconvenience? That's really what I'm trying to get to.
I understand Your Honor's question. I believe it would, Your Honor. I believe that it would.
It would.
I believe that the factors, once the Court has decided, the factors have generally not changed. It's conceivable that as the case progresses, the factors for forum nonconvenience could adjust, including whether there are or are not remaining claims that deal with only foreign law and factors like that. But I don't believe the factors will substantially change as this case progresses. But there are the facts on Mashrek Bank that were applied. The parties are not New York residents. They're not even U.S. residents. Ultimately, you have a foreign agreement between foreign residents for performance in a foreign country concerning foreign investments.
We have several different agreements here that the plaintiff is alleging claims under, correct? One is the shareholder agreement, but there's also other agreements. And those other agreements seem to choose on their face New York law, no?
There are other agreements. Those other agreements, however, are not agreements on which Mr. Wilson's claims are based. As the Second Circuit and the District Court found when Mr. Wilson's claims were in federal court, his compensation claims arise only out of the shareholders agreement and the purported oral agreement from 1997.
But aren't we talking about convenience? So are we restricted to, I mean, it sounds like what you're talking about is more along the lines of if we're looking at the question of personal jurisdiction, or, if an entity has substantial contacts with a forum, even if it may not be directly related to the very agreement that you say is the operative agreement here, wouldn't that still be a factor that could be considered under the forum nonconvenience analysis?
I believe that factor would come in, Your Honor, in terms of the difficulties for the defendant in defending the case, the contacts with the jurisdiction. And that is a factor that is included in analysis of the forum nonconvenience factors. The issue here, however, is not going beyond that. For instance, if the appellate division's ruling were to stand, any employee in a foreign country of a foreign employer engaging in management of foreign investments could claim that because some of their paycheck came from investments from a New York bank.
Well, but
They
don't we-
could bring a claim.
there's a lot more here than that, isn't there?
Not much when you get to the claims. Now, Mr. Wilson claims he was involved in designing that system, but his claims are not about the design. They're not about the joint venture or these other agreements. His claims are about what is his compensation to be.
As to which claims is he not collaterally estopped, in your view, by the Second Circuit's opinion?
He is not collaterally estopped, I believe, to the breach of contract claim for breach of the shareholders agreement or for the alleged oral agreement from 1997. That agreement, however, the oral agreement, is plainly on its face an agreement to agree. That's not opposed in the briefing before this court. On its face, it says the parties, I believe the phrase is, Mr. Wilson will be contracted on the following terms. That is a classic agreement to agree. It is also superseded by the shareholders agreement, which is the only agreement of all the agreements Your Honor has mentioned that all of the parties to this case have signed, and it has a clear totality clause that makes clear that there are no other agreements that the parties are relying on other than that agreement.
Did you move to dismiss based on documentary evidence?
We moved to dismiss, Your Honor, and including on issues related to complaint, or to documents that are related to the complaint. I believe the actual complaint has
Well, I mean,
these
under
exhibits.
A1, under 3211A1, let me step back for a second. Is your motion to dismiss in the record before us? Do we have a copy of that?
Yes, Your Honor.
Where is that?
It, I believe it is in the joint appendix that was sent to the appellate division. I'll get, when I come back up for rebuttal, I'll
Okay,
get you a page
thank you.
set.
I had trouble finding it.
Can I'm struggling a little bit with the relationship between the original complaint and the amended complaint. This appeal is solely on the original complaint, isn't it?
Yes, Your Honor.
So, but the amended complaint has been, a motion to dismiss that has been denied, so that means that the amended complaint is alive, is that correct?
It is, Your Honor.
So my question is what are we doing here until we know which complaint we're moving forward on?
Well, that issue's been before this court 3 times already, Your Honor, in terms of jurisdiction. And as we argued, and as they state in their own papers, the amended complaint did not substantially change the claims. And in fact, they relied on that fact before the Supreme Court in seeking to deny
I did a
our
side-by-side-
second motion.
I'm sorry, go ahead, finish your point. Finish your point.
They relied on the consistency of their claims to argue to the Supreme Court, Justice Ramos, that our motion to dismiss should be denied for the amended complaint, which he did deny for the reasons stated by the appellate division, but the appellate division didn't actually state any reasons.
But I am correct. The amended complaint that hasn't been appealed. That denial hasn't been appealed. So that's a valid complaint.
It is a valid complaint, subject to it being dismissed as a result of the ruling that this court would make for the reasons as we state in our response
You mean
to their motion
on
to
forum nonconvenience or the causes of action in the original complaint? Because I don't see how we dismiss the original complaint or the amended complaint for an action on the original complaint.
It would be the following way, Your Honor, that the claims in the original complaint do not state a claim. Then we would have an issue before the Supreme Court as to whether the claims are sufficiently different that this ruling dismissing the original claims also dismissed those claims.
So you're saying that a side-by-side comparison of the two complaints then would show us that they're essentially the same?
Yes, Your Honor.
I see.
for
Thank
the
you.
claims that were allowed to proceed by the appellate division. They did drop the claims that the appellate division dismissed.
I see. Thank you. Okay.
Thank you, Counsel. Counsel?
Madam Chief Justice, may it please the Court. My name is Terrence Reed, and I am here on behalf of Robert Wilson. First, I'd like to say that what the appellants are seeking here is to have this Court go back in time to review the sufficiency of a 5-year-old complaint that was superseded 2 years ago, as to which there's been a motion to dismiss the amended complaint that has been denied. They didn't take an appeal from that. There's been 2
It was
years.
denied based on the appellate department's decision in this case, which they have appealed. So if we agreed with them that all of the claims should have been dismissed, how can your amended complaint survive?
Well, with all due respect, we believe that the merits don't justify dismissal. We think that the appellate division was correct. But for purposes of this court, the amended complaint is not only pending, has been pending for 2 years, but it's now in cross motions for summary judgment, which have been briefed before the trial court. On the issue of forum nonconvenience, that issue has actually been briefed on our motion for summary judgment on forum nonconvenience. The issue that they say that...
Why aren't they correct about the error of law on the forum non-convenience?
Oh, well, because their timing is...
You don't, even the Supreme Court has said you don't have a right to a jury because you've got these equitable claims and you've relief requests, and so you've waived the right to a jury.
They did not, first off, they did not raise a challenge to the jury until after the appellate division decision. They raised it on remand for the first time, and in
But the
conjunction
appellate
with-
division did identify, the majority did identify this as a factor, and the dissent disagreed.
Right, and they didn't challenge that before the appellate division either. The point is, they first raised that after the appellate division ruled. And second, there's an important factor here that somewhat overshadows all of this, and that is that in February of this year, the defendants filed a multi-billion-dollar lawsuit in the federal court in New York, basically seeking to reopen the prior counterclaims they had in 2005 through 2008 in federal court in New York.
Wait, but let's stay with this lawsuit. Let me just go back to your point about didn't challenge this question about whether or not you had a jury trial right to the appellate department, but the appellate department reached the issue. Are you saying we're foreclosed from reaching this issue?
No, I'm not saying you're foreclosed from reaching the issue. I'm just saying that they didn't challenge the jury trial right until after the appellate court division decision. In the trial court, they answered the amended complaint. They asserted the defense of forum nonconvenience,
Right.
but they never moved to dismiss for the last 2 years.
On that basis?
On that basis. No,
But can't
so-
we reach it because the majority and dissent
Well,
reach that question, or the majority based its analysis in part, at least, on that factor?
we think this court should do what it did, or at least should take cognizance of what it did last November in the Rushad case, where this court said, look, these are issues for the trial court in the first instance. And in this case, they have exhausted 2 years of discovery in front of the trial court, including obtaining third-party discovery of Citibank of some 400,000 documents. Our motion for summary judgment takes into consideration all the factors, not just including what was at issue 5 years ago, but the current record, and also including the fact.
But
that
if we
the
agree
defendants-
with them, let's say the majority had said, look, these are the 5 factors, and these are 5 reasons we think that the forum nonconvenience motion should be denied. And we agree with them that one of those factors was improperly considered. There's no basis to consider one of those factors. Why doesn't that go back to the AD? Or why shouldn't we then decide otherwise?
Well, again, this court said in Rashad, you have a case with no discovery, which was the situation here. And this is 5 years ago. There's been a lot of development since, including 2 years of discovery. That the proper place to exercise that discretionary judgment is the trial court. And in fact, that's what's going on right now.
So your
In some-
position is that even if we agree with them that it was error to consider the right to a jury, but nevertheless, they're not foreclosed from pursuing this defense, And it very well could be that Supreme Court decides now based on the discovery or now based on what's before me, regardless of what the Court of Appeals now says, I can grant that, the Supreme Court could say, I grant the
And so
motion,
it
and then
is-
you'd
it is-
appeal it,
that?
potentially, and then you might appeal it.
Well, it depends on the result, of course, but,
If you lose, obviously, it's got to be held adversely to you, yes.
yes. Then we would likely seek an appeal to the appellate division, where they would have the same record that is now before the trial court on summary judgment.
I take it your view is that the Second Circuit decision doesn't collaterally stop any of your claims. Can you explain why, if
Well,
that's right?
The first and foremost reason is that the federal courts declined to exercise subject matter jurisdiction over all of plaintiffs' claims against these defendants. It denied the exercise of what's called supplemental jurisdiction, fundamental rule of due process.
That answers the question about res judicata, but not collateral estoppel.
The same principle applies. Both res judicata and collateral estoppel are inapplicable where the court doesn't exercise jurisdiction. You have to have a full and fair opportunity to present your claim in order to even have collateral estoppel or issue preclusion. So from Jump Street, there's no collateral impact of the federal court proceedings because of the nature of how they got sent back to state court. The federal district court judge says, I'm not exercising any subject matter jurisdiction over this case. So this goes back to the state court where it came from. And so that's our initial position. We also don't think that there's anything in particular about the rulings as they applied to, say, Citibank that has a negative consequences for our claims here. The court didn't address the contract claim of plaintiff vis-a-vis Dantas. In fact, the court was quite clear it wanted that to be resolved in the state court, which is where we are now.
Can you address the causes of action?
Sure. Briefly, on the cause of action, breach of fiduciary duty, both sides have pled, and indeed are pleading, the same joint venture. So we think the existence of a duty is both admitted by both sides through the pleading of the joint venture.
What can we consider on that aspect, the failure to state a cause of action? Can we consider other agreements, other alleged agreements, or are we limited to the parameters of the complaint?
You can consider what the trial court is now considering, and that is in the cross motions for summary judgment on this issue. You can consider
Well,
the
wait,
entire 10-year history of the
Well,
relationship of the parties.
one motion is for summary judgment, and another is for motion to dismiss. Aren't there different?
Well, but the issue is, what is the factual basis for the recognition of the duty?
I thought we were limited to the four corners of the complaint on a motion to dismiss for failure to state a cause of action.
Yes, that's true. But here, we plead a quasi-partnership, which is what the Cayman courts found. We plead a joint venture, which is what they are pleading. They
So
pled it.
what I'm asking you is you make certain allegations in support of those claims.
Yes.
And don't we have to accept those allegations as true?
Absolutely.
Or are we allowed to look outside your complaint to the defenses and the other arguments that are being raised by the defendants?
We submit that you need to look to the four corners of the complaint. In our complaint, both the original and the amended, we incorporate the references to the joint venture that they previously made in the earlier lawsuit, which they're renewing today in this new lawsuit. And those establish, a joint venture by definition establishes a fiduciary relationship. But more importantly, they have taken the position themselves, and we provided on page 41 of our brief, we quoted at length, their position to the federal court back in 2005, in real time when these events were taking place, that it was not permissible for the federal court to rule on the existence of a fiduciary duty as a matter of law. That is, by definition, a factual issue based on their assertion of a joint venture.
One of the things, and your time's running out here, it seems one of the cores are the defendant really has to show here the plaintiff's selection of New York is not in the interest of substantial justice, quoting the appellate division. So what's your response to that? What do you say to that?
Well, here,
Why is it in the interest of substantial justice?
it is in the interest of substantial justice because the side-by-side investment system, which is the heart of this, started in New York in 1996. ended in New York, so to speak, in 2008 through a settlement agreement to divest all of the side-by-side terms, which itself is exclusively governed by New York law, which has given rise to a new lawsuit trying to reopen all of these disputes as to who is entitled to the proceeds of the
That's the
side-by-side.
substance of it, but the procedural basis, which is the way I understand their argument, that no jury trial, et cetera, what do you say to that?
Well, that is a factor that the court can consider and that the appellate division did consider at a time when they had not raised any challenge to the jury trial right. But it's completely overshadowed by the fact that all of these events are rooted in New York. The operating agreement, which covers the entire joint venture, requires application of New York law and has a New York forum provision as well. So there's a bouillabaisse of New York contacts here. And, the jury trial right is one factor amongst many, but it's certainly not dispositive. And we take the fundamental view, which is if New York is a good enough place for them to bring a lawsuit, it's a good enough place for them.
But is your position that, I'm sorry, is the plaintiff's position that you are entitled to the jury trial right? To a jury? Is that the Supreme Court got it wrong?
To be honest with you,
Please, that would be refreshing.
we think so. We think that there's a constitutional right to a jury. But this case has enough issues as it is. We anticipate that their summary judgment is going to be denied. Ours will either be granted or denied, and we'll be in trial within 3-4 months.
Thank you, counsel. Counsel?
Thank you. First, Judge Stein, the motion to dismiss itself is not in the record in the joint appendix. However, it's on file at February 19, 2013. The affidavit in support that puts in some of the evidence we relied on is in the record starting at page 73 of the joint appendix. With respect to the timing of motion to strike the jury, no need to do that before trial. We did it. That issue was not appealed. There's clearly no right to jury in New York where there are equitable claims, even if those equitable claims are later withdrawn or dismissed. The Al Rashid case is not applicable. That was a case where there was no exercise of discretion by the Supreme Court or the appellate division at all. This court declined to exercise discretion over something that hadn't been exercised by the courts below in the first place. To one of the questions earlier to my colleague, if there is one factor that is wrong in the decision below, either this court needs to render in the opposite direction or to send it back for reconsideration to see whether that alters the mix of the analysis for forum nonconvenience. With respect to the issue of the joint venture points that my colleague has made, we do have a lawsuit that relates to a joint venture that is different than any venture that Mr. Wilson was a part of. He's clearly not and does not allege to be a member of that joint venture. Instead, the shareholders' agreement is clear that there is not a partnership relationship among the parties to this lawsuit. And there is no finding in the quasi-partnership context in this case. Instead, I'd refer to the 2002 Privy Council DeMarco decision, which makes clear that a shareholder in Cayman Islands has no rights of a fiduciary nature. Instead, what they have is the ability to go for a winding up procedure, to wind up the entity. That is their sole claim. I refer to paragraphs 13 to 16 of that decision. It makes clear that unlike English law, where there are rights for oppression for minority shareholders, there are no such rights in the Cayman Islands, which is what matters here.
Of course, that would be why you'd have Cayman Island law, but you still have the New York forum selection, right? Isn't that what?
No, that agreement has Cayman Islands as a forum selection.
Oh, I see.
Non-exclusive, correct?
Pardon me?
Non-exclusive selection.
Non-exclusive, that's correct.
I see.
Well, I'm sorry, it is exclusive for Cayman law to apply. It's non-exclusive for Cayman jurisdiction.
Right.
Thank you, counsel.